Cool, guys. So thanks for joining us, and yeah, nice to have you guys back on this webinar, and thanks for joining. So, guys, today what what I decided to discuss was I decided to relook at this issue of powers of attorney and signing documents overseas. I kind of looked back at my notes to try and see when last we dealt with it, and as far as about I think about 14 months back, I couldn't see anything. That's about as far as I could get. So I thought, we've had a bunch of queries that are in regard to this issue, and it's actually kind of an ongoing issue. So I decided that what I would perhaps do is revisit the issue of powers of attorney and signing documents overseas. Um, I see my battery is running low, and my PC is running low. Let me plug it in here quickly, else I'm going to lose everyone all together. There you go. Um, Sorry, everyone. Sorry. Okay, so as I was saying, I'm going to discuss these two issues. It's powers of attorney, signed documents overseas. The two kind of go hand in hand. And if I can just start with these kind of overall general comments, the importance of understanding how powers of attorney work and how signing documents overseas work is because they are such practical um, application and importance in the work that we do every day. So just to give an example, if you go and see a seller and the seller is immigrating, um, or you go and see a seller and the seller is going to be doing a lot of traveling, or they're going on a long holiday or something like that, then what we want to try and do is we want to try and have a scenario where they sign a power of attorney before they go. So for those of you who know the conveyancing process, you'll know that when documents need to be signed overseas, it's a long and arduous process in some cases. It causes a lot of frustration. It takes a lot of time. It's expensive. And I think most importantly of all, it delays the conveyancing process. So as you know, the quicker the conveyancing process goes, the better it is. The less time we have this matter in our office, the less time there is for problems in the office, for frustrations, for the buyer's to take occupation, for problems to arise. So it's in all of our interests that we really look at these issues of powers of attorney and understand the process of signing documents overseas, so that we can avoid having to sign documents overseas where possible. And I just want to give you guys a few insights into it. So first of all, there's two kinds of powers of attorney. One is a general power of attorney, and one is a special power of attorney. And I'm going to kind of look at them. I'm going to look at both of them during the course of this webinar. So uh, you need to meet your clients and determine, do we need a general power or special power? A special power of attorney is a power of attorney that relates to a specific project. So it only relates to the sale of that particular property. And a general power of attorney is a power of attorney where general powers are granted. So a general power of attorney is it's a standard form document. Um, if anyone wants one, you're welcome to drop me a mail and I'll email you one. They're completely standard, but they give broad powers. So, for example, if you have somebody who's not going to go overseas and you want to look after their affairs, you must close banking accounts, you must transfer funds, you must deal with their cars, etc., etc. A general power of attorney may be appropriate. But where, for example, you have a scenario where you got two owners of property, the one spouse will go overseas, the one spouse will stay here. The party who's going overseas can transact for themselves, but the party here is going to sign documents. Then we want to use a special power of attorney. So I always prefer to use a special power of attorney, because a special power of attorney is limited in its effects. A general power of attorney is a very powerful document because it gives the person who's got the power of attorney power to do all kinds of wide transactions, which I don't think is always a good idea in every instance. So we'll come back to this issue of general and special powers of attorney now, but I think what we must understand, though, guys, and this is so important, that when we're dealing with powers of attorney, with their general powers or special powers, there's a lot of deeds office requirements. So what we sometimes find is the agent says to the seller, "Okay, so I see you traveling overseas. It's a good idea to get. We must get a power of attorney drawn up here." And the seller will say, "Don't worry, I already have a power of attorney, so just leave it with me. It's okay, I've got it." And you go, "Great." Market the property, sell the property. We receive after purchase. We say to the seller, "Please, can we see your power of attorney?" The seller says to us, "Here it is," and we say, "It's not usable." It may be usable in the sense that it's legally binding and it's a valid power of attorney, but the deeds office has very specific requirements, and those specific requirements must be met in order for the power of attorney to be acceptable to the deeds office. And guys, it's for this reason that what we suggest you do is, when you need a power of attorney done, a special power, please let us draw that special power of attorney for you. Um, If the client says they have one, we suggest you say to the client, "Give it to us now, right early in the process while you're in the country, and we will assess it. We'll tell you if it's workable. If it's not workable, well, then we'll get a new one drafted." So, for example, the requirements are the power of attorney has to have two witnesses. So it must be signed by the person granting the power of attorney and by two witnesses. If it goes over 2 pages, they must all initial the first page and sign and full on the second page. It must describe very comprehensively the grantor, the owner of the property, and the grantee and the immovable property. So, for example, if I get a power of attorney which stipulates that the address is 12 Komiki Avenue, Edenvale, that doesn't work. I need portion 12, Earth 12 are in the township of Edenvale. So I need the proper deeds office description. The other thing that the power of attorney is going to need, if it's lodged in the deeds office, is a preparation certificate. So that's that little certificate in the bottom right hand corner of any documents lodged in the deeds office. The conveyancer must sign that document to confirm that the conveyancer is accepting responsibility for the content of the document. So again, just to reiterate the point, let us draft these powers of attorney for you. If the client says they got one, then what we want to do is we want to check it for the client. We actually follow, a whole bunch of specific processes with signing documents overseas and powers of attorneys, but I'll kind of come to those as well in a moment. And by the way, guys, we have to have the original power of attorney if the client had one. So we have to lodge the original power of attorney. So let's just talk for a second about the validity of a power of attorney. And this is something that people don't necessarily realize or understand. And that is, a power of attorney is not a document that you take to do whatever you want. The power of attorney is used on the instruction of the person who granted the power of attorney. So the principle here is this, is if the person who granted the power of attorney is incapable of withdrawing the power of attorney, then that power of attorney is no longer valid. Although you may have a physical document, it's no longer valid. So to give you a nice example of this, some years ago, I had a call from an estate agent, property here in Bryanston. Client said to me, "Listen, he was selling a property, husband and wife. He's selling the property. The seller wanted 3 million rand. Couldn't get the price. Seller was adamant. The seller went to hospital, fell ill, and went into a coma. Okay. And this is the point at which the client called me and said to me, "Listen, still marketing the property now as a buyer for 2.4 million rand, and the wife of the seller now wants to accept the offer to purchase, utilizing a power of attorney that she has." And the question to me was, is the power of attorney valid? Can the wife accept the offer to purchase on behalf of the husband using the power of attorney? And what I said to the agent was, no, you absolutely can't. Because the fact that the husband is now in a coma and no longer has the ability to withdraw the power of attorney that he granted, what it means is the power of attorney is invalid. So we didn't go into the transaction. And I also said to the agent at the time, I said, the risk that you run is, if the power of attorney, if the husband wakes up, so let's assume that the husband goes in the coma, the wife uses the power of attorney, sells the property for 2.4 million, and transfer goes through. Husband then wakes up, recovers from his coma, comes out the coma and says, hold on, you've now sold the property for 2.4 million rand that I wanted to sell for 3 million rand, and now goes and undoes the entire transaction because the wife didn't have the authority. So that's what the risk is. The other scenario we have is we have people who have elderly parents. They sign powers of attorney or general powers of attorney whilst the parents are still compos mentis. As the parents' illness, it might be dementia, Alzheimer's, whatever it might be, as those illnesses progress and the mental state of the parents gets worse and worse, the children still they want to use the power of attorney. The problem with that, though, is that when the parents' state of mind gets to a state where they can no longer understand the actions, in other words, they're incapable of revoking the PA, well, then that power of attorney is now no longer valid. And again, there's always risk in these elements. There's risk in going ahead with these transactions on the basis of an invalid power of attorney. So the question is, well, what is the solution? What is the solution under those circumstances where the parents get old, Alzheimer's or dementia sets in now, and now they can't revoke the power of attorney, therefore it's invalid. Well, what is the solution? Well, there's a number of solutions. The first one is not a nice solution, and that is to wait for them to die. And I know that's a pretty stark thing to say, but the one potential solution is the owner property. You wait for them to die. Once they die, the property falls part of the estate, and then you sell or deal with it within the estate. The other option that you have is to approach the master of the High Court in terms of the Mental Health Act, and you can have an administrator appointed. And the other alternative is to approach the High Court for the appointment of a curator bonus. The rights and powers of the curator bonus, the administrator are fairly similar. Just the difference, though, is the process of going to the master of the High Court is a lot easier and a lot more cost effective than going to the High Court for your curator bonus. So that's actually what we've been doing of late with these kinds of matters, is that we go to the master of the High Court, and we have a we have an administrator appointed. Okay, so I think I've spoken about general powers of attorney already, but just to take the issue a little bit further, what we must understand about a general power of attorney again is it's broad powers. I'm reluctant to let people sign powers of attorney or general powers of attorney unless they absolutely have to. If you're going to use a general power of attorney, it must be registered in the deeds office. So in other words, it gets lodged in the deeds office under a separate cover, and then it gets a GPA number, a general power of attorney number, and it's like a title deed or a antenuptial contract. It's registered in the deeds office, and then can be used for future reference. And that's also why I'm saying, one must be careful, because it's registered in the deeds office. It's there for future reference. It's out there, and that kind of makes me nervous. I prefer to use that as a special power of attorney, especially for our circumstances in dealing with immovable property. So it's more limited in its application. So guys, this is an example of a special power of attorney, and this is in my property law manual, so you can have a look it up. So although the example's there, guys, it's really just there for you guys to see. Please rather let us draw these documents. For example, are the undersigned Marius van Rensburg, ID number, marital status, do here nominate and constitute and appoint whoever I'm going to appoint, and then I've got the property description as well. The reason why I say let us draw these documents for you is because you've got to get the marital status exactly correct per the deeds office requirements, and you need to describe the property exactly per the deeds office requirements. And it's so important in dealing with these issues. For example, you might be dealing with sectional title of property. There's exclusive use areas. Those must be dealt with as well in dealing with the property description. And then you got your first couple of points: to market the property for sale, to nominate an agent, sign agreement to sell, sign conveyancing documents. What we do when we get this document signed, guys, is we at the same time get a whole bunch of affidavits signed: personal affidavits, so a FICA affidavit, marital status affidavit. So we supply this document with all the affidavits. So whilst the client's in the country, they sign the documents. We have everything in a file over here. They go overseas. You market the property, you sell it, we get the offer to purchase, we can then process the transaction based on the power of attorney, which we then lodge in the deeds office as well. But the point is, we have the guy's ID documents, we have the affidavits, we have the power of attorney. We don't need that person in South Africa anymore. So just two more points I want to make on this issue. One is that the document must be signed, this power of attorney. It's only of any use to us if it's signed when the client is in South Africa. So in other words, if the client's already living overseas, then there's no point, because they're going to go through the same rigmarole of signing documents overseas as for this power of attorney as they would for the conveyancing documents. So the client must be in South Africa to do this simplified process. They can't sign this document overseas. Okay. So that's the first, and that's why it's so important to catch the people. So we often get a call saying, Marius, my client's going overseas, they're leaving on Monday. Please, can you get this drafted? Guys, it doesn't take a long time. I need a property description for a deeds office search. I need an ID document of the person's granting the power. I need document to the person receiving the power, and I can then drop my documents. I can literally, if you email me now, I can have the documents ready within an hour, and your clients could either email them to sign, or they can come in here to sign the documents, whichever happens. I forgot my other point, but it'll come to me now. Yeah, so the clients must sign the documents, whilst they are here in South Africa. Okay, guys, let's move on to the next topic, which is the signing of conveyancing documents overseas. So the whole reason for signing the power of attorney is so that we can avoid this process of clients signing documents overseas. Because as I said in the beginning, if the clients, and guys, sometimes this is absolutely unavoidable. So if your clients are living overseas, your buyers or your sellers, they're not coming to South Africa, then that's what it is. I mean, it's that then that's what it is. Then we must sign the documents, sell the property here and sign the document, and get the document signed in a different country. And the point that I wanted to make earlier, that I forgot, that comes in here, is that we sometimes make the mistake of thinking that that the sale agreement must be signed at an embassy or going through this process. We must understand that we must differentiate between the signing of the sale agreement and the signing of the conveyancing documents. The signing of the sale agreement, you can email your client overseas, your client can sign the documents and email it back to us. You then have a valid and binding offer to purchase, no problem. The conveyancing documents are, however, different. See, the conveyancing the reason why the conveyancing documents need to be signed through this very formal process is because those documents get lodged in the deeds office. So therefore, they must comply with deeds office requirements. And what the deeds office does is the deeds office insists on complying with the high court rules for signing documents and authentication of documents overseas. Okay, so that's the reason. So please don't worry about emailing a document overseas, getting a sign and getting an offer to purchase. It's the conveyancing documents that we are concerned about. Okay. So when it comes to signing documents overseas, the complexity of how complex it is to sign the documents overseas depends on where you live. Okay. So if you live in a country which is part of the Hague Convention, it's very, very simple. So, for example, if you're living in Northern Ireland, Swaziland, Botswana, United Kingdom, or Great Britain, Lesotho, or Zimbabwe, then all we do is we can send the documents over to a notary public, and the notary public can sign the documents. In fact, let me take a step back. There's documents which you can sign. Some countries you can sign the documents at an embassy, or you can sign the documents at a notary public. So if there's an embassy, though, those are your two options. You sign at an embassy or a notary public. If you sign in an embassy, you deem to sign on South African soil. That you go to the embassy, you sign the documents, they get stamped, they get sent back to us, no problem. Sometimes what we find, though, is that the people live in countries where the embassies are not close by. So, for example, we have people living in the Far East, or we have people living in the Americas, where you need to take a 3 or 4 hour airplane ride just to get to the local embassy or consulate. So it's not possible So but if you can go and sign at an embassy or consulate, that's the simplest thing to do. If you can't, well, then you must sign at a notary public. If you sign at a notary public, again, here it depends on where are you living in the world. And to come to my earlier point, which I jumped ahead to, if you're living in a country where we follow the Hague Convention, which is Swaziland, Botswana, UK, Lesotho, Zimbabwe, it's simple. You go to the notary public, you sign the documents, and there's no more formalities. Those notaries, because of the Hague Convention, are recognized without further ado, and they simply get sent back to us, and we can lodge and register in the deeds office. If, however, you're in a country which is not part of the Hague Convention, such as the countries in the Far East or the Americas or Australia or New Zealand, well, then you have to go to a notary and you must get it signed in front of the notary, and the notary must complete what's called an apostille certificate. Now, I've got an example of the apostille certificate coming up, but just to explain to you what an apostille certificate is, it's a document in terms of which the notary is authenticated. So if you're part of the Hague Convention, the notary is automatically authenticated. If you're not part of the Hague Convention, the notary must be authenticated. So you sign your documents, then the notary completes the apostille certificate, and the notary takes that apostille certificate to their local high court or their local authority. That local authority then authenticates the notary in that country as a notary, as a duly admitted notary. That document comes back. So what we get back is the signed documents, plus a notarial certificate saying that the notary signed the documents, plus we get the apostille certificate, and we lodge that in the deeds office, because our deeds office wants to know that this notary, who's not in a Hague Convention country, is actually a notary, and therefore we need the apostille certificate. What we always do, guys, is and we try and follow a very careful process. If I'm going to send documents overseas, first of all, I try and actually not email them unless they're very simple. I try and courier the physical documents so I can mark off exactly where the client needs to sign. And then what we do is we tell the clients, sign your documents at the embassy or the notary and email them to us first. Scan and email them so we can check them. Once we've checked the documents, we then email the client back and say, yes, they are correctly signed. And then the clients can courier the documents to us, so we need the originals. And we do that because what we find is people don't read. So we tell them to sign the documents in a specific way. They don't sign in the specific way. They come back to us and the users won't accept it. And this is particularly when we're dealing with bonds being signed overseas. You've got a thick wad of documents, and you need to initial and sign in exactly the right places to be acceptable to the bank and the deeds office. And that's why we would try and take a cautious approach. So if you ever see this if you ever come across this in practice, you'll be able to see and know and encourage people, listen, it's for your own good that we take a slightly more cautious approach in regard to the signing of the documents. Okay, so this is a slide. I think I've covered most of what's on this slide, and I'm just talking about the apostille certificate, and the function of the apostille certificate again is to authenticate the legal standing of the notary in the country in which it stands. Guys, don't underestimate how arduous this process can be. We have clients, for example, I don't joke when I tell you this. We've had clients who live in China who literally take you know, quite literally take bus rides and trains and go on boats, the works, and they travel for like a day and a half, 2 days, just to get from where they live to the notary or the embassy. So it's really important that we really try as hard as we can to draw the documents as carefully as possible to make sure the documents are correct when they get there, signed correctly, and then come back to us correctly. And again, guys, this is the reason why, if at all possible, and it's not always possible, we want to make use of a special power of attorney, because that avoids this whole process of having to get these documents signed overseas. Okay, guys, and then my last slide is that is what the apostille certificate looks like. You can see it refers to the Hague Convention. It's signed by the notary, goes to the local authority. So to give you an example of how it works in reverse here, I have notaries in my office, and sometimes they're required to notarize documents for clients who want them for overseas purposes. Clients need to come into our office. They sign the documents over here. Once they've signed the documents over here, we then take the same apostille certificate. We send it to our high court. There's a registrar at the high court who has a list of all the admitted notaries in the country, and the registrar then signs the apostille certificate to authenticate the notary here at Schindler's offices. We get the apostille certificate back, and that apostille certificate is then delivered. So I know, guys, that sounds, I'm sure if you haven't come across it before, it sounds complicated and unnecessary. And the truth of the matter is, it is complicated and unnecessary. And to the extent that we can avoid it, we absolutely do by using those special powers of attorney. But it's so important also, guys, from even just from a FIC and a client identification point of view. So when we have clients overseas, we don't meet the clients. You don't meet the clients. We meet them face to face. Well, we don't meet them face to face. We may FaceTime, we may Zoom call or Teams call with them. We talk to them on the phone. We don't meet them face to face. So it's quite an important function sometimes when they go and sign documents at the embassy or notary overseas. They can identify, and that actually complies with a FICA requirement of, if you think about this in terms of most of your risk management compliance programs, foreign people are deemed as high risk. High risk means we must identify them properly. By going through the apostille, the embassy or the notary process, they are then identified properly. And that even is so important for conveyances, because when we sign the documents, we certify that these people have been identified. So we need an external process to identify them. Again, probably pretty complicated. I think that the point of which I want to try and convey to you guys is try and get that the special power of attorney done. It really does save quite a bit of time and pain. So I have a question here: is there a cost for us to do the power of attorney? No. What we do, we don't charge for the power of attorney. It's just part of the service that we offer to agents. And there is an advantage for us as well, because if we get the if we do the power of attorney, when the property is sold, there's a better chance that we will get that transaction. So there's a benefit for us in terms of that. There's also a benefit for us and you in terms of we save ourselves the admin of having to send documents overseas, which is of great value to all of us. The next question is asking about curator ad litem and curator bonus. So if you go through if you appoint a curator in the High Court, right, it's a two-phase process. First of all, what the court does, you make your application. The court appoints an interim curator, right? So it's an interim curator, and that curator's their job is to go and investigate the position of the person for whom we're going to be granting the curator order. That interim curator, which is the curator ad litem, is normally an advocate appointed by the court. That advocate reports back to the court, and they charge an absolute fortune to do that. They can report back to the court, and then you go back to court a second time on the basis of the curator ad litem's interim report. And then the court makes the final decision as to who's going to be the curator, the actual final curator boni. All right, so if you go through the High Court, it's a two-phase process, and that's why it takes a bit longer. It's a bit more expensive. As I mentioned earlier, what we now do is we prefer to go, unless we absolutely have to go to the High Court, we prefer to go through the Mental Health Act, which is we apply to the Master of the High Court for the appointment of an administrator, because that administrator's got roughly the same powers. And then again, guys, being a curator or administrator is not a joke. You need to submit a monthly or quarterly reports to the Master High Court. You need to report. You don't just go and do whatever you want. It's a pretty responsible thing that you have to have done. All right, guys. I hope I've covered the two topics sufficiently that you understand how it works. And as always, guys, thank you so much